Well, the sister of the former Jammu and Kashmir Chief Minister Omar Abdullah has now approached the Supreme Court and has appealed or filed a plea for the release of her brother Omar Abdullah. This case will be heard very soon in the top court.
Sara Abdullah Pilot fighting for her brother, former J&K Chief Minister Omar Abdullah, who has been in custody since 5th August, now detained under the stringent Public Safety Act. Sara's habeas corpus petition, that is to produce her brother before the Supreme Court and to set him free, will be heard by the Supreme Court soon. In her petition, the ex-CM's sister says Omar's arrest is a grave violation of constitutional rights, including freedom of speech. There is a consistent and concerted effort to muzzle all political rivals. The detention order conflates government policy with the Indian state, suggesting any opposition to the former constitutes threat to the later. Abdullah is not even served with the material which formed the basis of his detention. Abdullah's public statements and messages during his detention reveals he was calling for peace and cooperation, a message which in Gandhi's India cannot remotely affect the public order. Mr. Abdullah's preventive detention was to end on February 5th, but on that day, government used Public Safety Act against him and former CM Mehbooba Mufti, extending their detention by 3 months without trial. The government hasn't explained the so-called reasons for detaining Abdullah under the PSA. For instance, that he is a popular figure among masses and has tremendous potential for diverting energy of common man for any cause, and managed to convince people to vote despite a boycott call by terrorists and separatists. But Abdullah's sister in her petition denies this. She says the contentions fly in the face of his tweets shortly around the time of his detention, in which he cautioned people against resorting to violence and taking law into their hands. Mehbooba Mufti, whose family is yet to approach the Supreme Court, has been accused of dangerous and insidious machinations and usurping profile and nature as daddy's girl. Congress's Priyanka Gandhi Vadra tweeted rubbishing these reasons, saying the government must free both as it has no reason to charge them.
The top court has agreed to the request of the petitioner's lawyer to list the case at an early date. Now the case is likely to be heard this week. In New Delhi, Arunachalam Vaidyanathan, NDTV.
Well, the point over here is that Mehbooba Mufti and Omar Abdullah, not to mention Farooq Abdullah, have been under detention for 6 months already. And now with the stringent Public Safety Act in Jammu and Kashmir being slapped on them, it's unclear whether under normal course when they would be released. This is something which is slapped over and over again against those the state wants behind bars. These are 3 former chief ministers. They've all been seen to be India-centric leaders. These are all pro-India, mainstream political leaders. So therefore, one would think that the state government or the authorities in Jammu and Kashmir would have a lot of very comprehensive and concrete material against Omar Abdullah and Mehbooba Mufti to say that they were a danger in the present situation in Jammu and Kashmir. So let's examine for a moment whether they have got any of that. Joining us now, Hasnain Masoodi, Lok Sabha MP of the National Conference, Ravinder Kishore Sinha, Rajya Sabha MP of the BJP, and very privileged to have with us Raju Ramchandran, Senior Advocate of the Supreme Court and the former Additional Solicitor General of India. Mr. Ramchandran, let me come to you first. One of the points mentioned in the order against Omar Abdullah is that he convinced the electorate to vote in huge numbers even during peak militancy. Isn't that what a politician is supposed to do? How can that be held against him?
Vishnu, in fact, it shows that Omar Abdullah was able to persuade people to adhere to the constitutional path, that is, go and vote. And I couldn't believe my eyes this morning when I read that this was cited as a ground against him. Yes, of course, you're right. That's what a politician is supposed to do. But here what is significant is he is telling them, don't boycott elections. Vote in elections, which is adherence to the constitution. This is so bizarre.
Yes.
The Public Safety Act has been a weapon with the state of Jammu and Kashmir and now the Union Territory for so many years. One would have at least thought that it would be administered with more professionalism and not in such a ham-handed, amateurish way.
Yeah. Mr. Sinha, let me come to you next. It says Omar Abdullah, and we'll talk about Mehbooba Mufti as well, quote, adopted a radical methodology by way of instigating people against the centre's policies. But if you actually look at his tweets on the 4th and the 5th of August, that's when he was detained on the 5th, let's see what he says. He says violence will only play into the hands of those who do not have the best interests of the state in mind. This wasn't the India Jammu and Kashmir accepted, but I am not quite ready to give up hope yet. Let calm heads prevail. God be with you. While I have been focused on Kashmir, I must add a word for people in Kargil, Ladakh and Jammu. I have no idea what is in store for our state, but it doesn't look good. I know many of you will be upset by what unfolds. Please do not take the law in your own hands. Please stay calm. Were these the words of somebody who adopted radical methodology to instigate people against the centre's policy?
Actually, there must be some regions, some intelligence reports, some actual concrete evidences. Only on the basis of such actions are taken. Now they have moved to the Supreme Court of India, and Supreme Court of India will examine all the facts placed by both the sides, by the government and by the petitioners, and court will decide.
Mr. Sinha, isn't it strange that this is a man, Omar Abdullah, who was a Minister of State in the External Affairs Ministry. I believe he was a Minister of State dealing with commerce and industry also in the past. He's been a Chief Minister. He's been somebody very close to the centre, to the BJP, and yet all of a sudden he is seen to be some sort of an anti-national, right? Favors radical thoughts which he has turned into actions. Has this realization come belatedly to the government?
Not exactly. Not exactly. He has already been in politics for 3 generations. But the thing is that whenever the intelligence agencies and the government gets a concrete evidence, then only action is taken.
Okay. Mr. Ramchandran, one of the points mentioned in the writ petition filed today was that this evidence that Mr. Sinha speaks about wasn't presented to Omar Abdullah. Now, how does the law work? Is somebody obliged to tell him this is the evidence against you?
Yes. Now, typically an order of preventive detention requires, firstly, that the grounds of detention be supplied, and secondly, that the material in support of such grounds be supplied to the detainee, because it is only then that the detainee can make an effective representation. I think I need to clarify what the law of preventive detention entails. The scope of judicial scrutiny is very limited. The only safeguards are supply of grounds, supply of material which enables an effective representation to be made, because the court doesn't sit in judgment over the subjective satisfaction of the detaining authority, and therefore the material is required to be supplied. So that's a very legitimate grievance raised in the writ petition.
Mr. Hasnain Masoodi, I mean, you're a very well-known lawyer yourself, in addition to being a political leader. Just wear your lawyer's hat for a moment. If you came across documents written in this manner, not just against Omar but Mehbooba as well, let me just read out the bit on Mehbooba, which I found bizarre. Referred for why was the PSA put on Mehbooba Mufti? The government dossier says referred for her dangerous and insidious machinations and usurping profile and nature as daddy's girl. One really needs to ask, who's written this?
Well, one cannot believe that the detaining authority, who is discriminated in the present case as elsewhere also, one cannot expect such language from the detaining authority. I mean, with this kind of vagueness, I mean, does not carry the weight, or does not tell us that what were the grounds, what is the real reason to slap detention order on Mehbooba Mufti, or for that matter even in case of Omar Abdullah. You know, as you rightly point out, say it is so vague that they say that the reason to slap this order is because he was in a position to persuade people to defy a call for poll boycott. Now, as you know that Article 22 leaves room for preventive detention law, but all the same, it provides for some constitutional guarantees. First is that the detainee is to be given an opportunity to represent first to the government against the detention, and also then advisory board, and you know how things go. But he will not be able to, as was rightly pointed out by learned counsel, I mean on the panel, he cannot make use of these constitutional guarantees effectively unless and until it is with all clarity it is brought to his notice that what are the reasons that it has been slapped on him. Okay. And then added with the material on from which the ground system, on which the grounds are based.
Right.
That material is also to be provided. Then only he can make effective use of his constitutional
So that
guarantees.
will have to be provided to the court. It's almost certain that the court would say, where is all the evidence
In
for
the
this? Because what has been provided so far, sir, in terms of some of these tweets, they don't appear to be, I don't understand how these could even remotely be considered.
That's what I say.
As something which could,
as
for example, in Mehbooba Mufti's case, let me quote, prisoners are entitled to a fundamental human rights, and using brute force to quell protests is a clear violation. This is Mehbooba's tweet. Pertinent to mention that inmates protested after the alleged desecration of Quran. She's talking about a particular instance. The government of India wants to turn Kashmir into an open-air prison and convert actual jails into Guantanamo. Now, you can agree or disagree with her, but how is this even remotely something which would go into a police/administration document on the basis of which you have put her in continued detention? Mr. Sinha, I can go through 10 examples like this. What sense is there in this?
Actually, let the government produces the evidence.
Would you accept,
there must be something
but would
very
you accept,
vital.
Would you accept, Mr. Sinha, that producing legal documents like this on the basis of which a chief minister, or forget chief minister, any citizen is put behind bars is deeply problematic? Would you accept that?
Actually, certain acts are such, like PSA, or during emergency we were detained under MISA, Maintenance of Internal Security Act. These acts are such where government has very wide powers, but government has to produce evidences, and these two great legal luminaries are sitting on the panel, and both are very big experts, respected people. They would know it better.
All right. Raju Ramchandran, another quote over here from the dossier, as it were, presented to Mehbooba Mufti, on the basis of which he has been detained. The subject is recognized as a hard-headed and scheming person whose actions have been ranging from speeches glorifying militants to creating fears among a majority population based on cheap politics among the masses. So, you know, the politics of Mehbooba have been dubbed cheap. That's the opinion of someone, fair enough. You know, you can call it cheap, expensive, call it what you want. But how are these, again, examples, remotely examples of something which qualifies to putting a person effectively behind bars? It seems an outrage, sir. What has been shown so far?
Under the J&K Public Safety Act, an order of preventive detention can be made on two grounds. One, that the conduct of the detainee is prejudicial to the security of the state, or that it is prejudicial to public order. So there must be a nexus between what has been said to these two considerations: security of state or public order. Now, except for the speeches glorifying militants, which need to be specified, otherwise it's an absolutely vague ground. What were the speeches? When were the speeches made? So that must fail on the ground of vagueness. All the other allegations which you have read out must fail on the ground that they have no nexus whatsoever to the purpose of detention under the Act, namely security of state or maintenance of public order.
Okay.
So I would say that this is a classic case or a textbook case for a writ court to issue a writ of habeas corpus.
All right. And that, I mean, you're hearing it from one of the country's senior most lawyers and advocates. But again, this isn't remotely to prejudge what may or may not happen in the Supreme Court. That's certainly not our purpose in this debate.
That's right. That's right.
I just...
that's right.
Mr. Masoodi, Mr. Masoodi, one last word to you. Is it also not true that even if there is relief granted by the Supreme Court, assuming that that is the case, or maybe that it may not be the case, if there is, that the government in Jammu and Kashmir can slap this again immediately?
Yeah, that is what is usually done.
So therefore,
you know, but the law is settled that you cannot reuse same grounds to slap a fresh order. And second is that, what is more important, see, why does law make room for preventive detention? Because it may not be, efficient to set criminal justice system into motion to meet an immediate threat to public order, as rightly said, and or security of state. That implies that whatever statement, whatever material is used, it must be not remote in point of time. Now, in this case, what is an extra reason? Both of them have been in detention for last 6 months. So they had enough time even before that. And what, as London Council said, the co-panelist said that when was the statement made? Was it made 2 years back, 3 years back? If it was an offence that time, why was not a case registered? Why was not investigated? Because they had sufficient time to set into motion the criminal justice system.
That's an
but
important point.
Now you cannot use the 2 years back statement made 2 years back or just a year back, now say that the threat is present to public order or to security of state.
Mr. Ramchandran, would you like to come in on that? I don't know when all of these quotes were made, but they were...
But definitely not within 6 months or
in
reasonable
many
time.
cases, they weren't made within 6 months. So from a legal standpoint, what does that mean?
Yes. From a legal standpoint, another, because as I want to clarify again, the grounds of judicial review are very limited. But staleness of grounds, staleness of a ground, lack of proximity is a recognized ground in law for striking down an order of detention. And therefore, if a speech was made 10 years back, that would not justify an order of detention today. There has to be a proximate link.
Right. Well, that proximate link would be decided by, when these were made and whether there can be some sort of association with the political developments in Jammu and Kashmir and 370. And in many cases, a lot of these quotes were against 370 and 35A, but that's now changed. The reality in Jammu and Kashmir has changed. And this case is now being heard in the Supreme Court with Omar Abdullah's sister having approached the court with a plea that her brother be released. Mehbooba Mufti's family, perhaps a daughter, will be headed to the court as well, we are told, in the next couple of days. So these are some of the grounds, most of them in fact, on which these two ex-chief ministers continue to be detained. And we'll clearly keep asking more questions and perhaps wait to see if there's any more evidence at all. I'd like to thank all of you very much for joining us.